Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Welcome everyone to our Spring Forward legal update session for February. We're going to talk about breaking up with your employees. So my name is Hilary Page. I'm one of the lawyers here at SpringLaw, and joining me is Danielle Murray. If you are one of our clients, you already know that we're employment and contracts lawyers. Our firm is virtual and we're based out of Ontario, but we do service all of Canada. And welcome to those of you who are new to our webinars. If you do have questions throughout the webinar, you can feel free to pop them into the chat function and we will try to get to them. But we do want to respect your time and stick to half an hour. You can download today's slide deck under the handouts tab. So there's a PDF there for you to download. And if you want more information about our law firm, feel free to visit us at springlaw.ca. We have great resources there, including our blog posts, our guide for employers during COVID. You can subscribe to our monthly newsletter, and we've got a bunch of product offers there as well. So feel free to check us out there. And as I said, I'm Hilary Page. Danielle Murray is with me. And just a friendly disclaimer, we have to say this because we're annoying lawyers. So if you're attending our webinar, it is just legal information. So even if we answer your question, please don't rely on it as legal advice because we just don't have the context for that. Attending the webinar does not mean that you are a client of the firm. We'd love for you to be a client, but you need to be properly onboarded. And you know, the law does change quickly in Canada, quite quickly. So especially in employment law. So, you know, you're free to use the handout and everything is current as of today. But if you are relying on this in the future, you know, it may not necessarily be accurate at that time. Okay, so today we are going to chat about problem employees and how to address those scenarios. We'll talk about types of termination, elements of a termination package, and how to terminate an employee virtually. And I will hand it over to you, Danielle, to get started with our first topic.
All right, so we'll start with problem employees and how to best handle them. So what to do if you have a problem employee. First, you want to think about whether there's an accommodation issue here. What's underlying the employee's behavior or performance issues? Is there an addiction issue here, a mental health issue? Maybe the employees talked to HR or talked to you about their issues, and if that's the case, you want to think about, you know, is this a protected ground under the Human Rights Code? And usually, you know, if it's an addiction and or you know, it's very, very broad, but this would fall under a disability under the Human Rights Code. And there isn't really a list of what is considered to be a disability under the Human Rights Code. It's very broad. You know, it could even include things like irritable bowel syndrome, which I've seen in a case. So if you want to think about that, and if it is or it could be a protected ground, then, you know, the employee is entitled to accommodation, and so you'll want to accommodate that employee as much as you can, as best as you can. And usually, like the the standard is up to undue hardship. So
very high.
yeah, it's very high.
Yeah.
And then if that it isn't the case, and it's just a performance issue, and you haven't heard of any underlying reason that could be a protected ground, then usually it would be a good idea to document things and use what we call progressive discipline, which is over time giving warnings, and possibly some discipline if needed, and just papering that, so that eventually if you need to terminate, or if you want to terminate for cause, and we'll get into what a for cause termination is later, but if you want to terminate for cause, having that documented, the documented warnings and the documented progressive discipline will help you. Otherwise, if you want to terminate without cause, you wouldn't necessarily need this. But we'll get into the different types of terminations later.
Yeah. And I would just maybe add on to that, like, I think a lot of the problems we do see with employee performance, they often are related to um, disability or, mental health issues, like just so common, like, being late all the time, or, not being able to handle workload or things like that. And the employer does have a duty to inquire. So it's not like the employee never told me. Like, if you're noticing something, you do have that duty to inquire under the Human Rights Code and accommodate up to the point of undue hardship. So it's a
Right.
it's a high bar, but it's so common that when we do see issues, they are related to things like mental health very commonly. So we're going to talk about types of terminations. So there are really only two types of terminations. There is a without cause termination, and there is a for cause or with cause termination. Some people think, what about a mutual separation? And legally, that doesn't really exist, in my opinion. So, without cause termination is where you don't have any specific reason to terminate the employee, and you just it's not working out. And under the law, you need to provide that employee with notice of termination, and you can terminate any employee at any time as long as you provide them with sufficient notice. And we're going to talk about what sufficient notice it would be. Um, but often people come to us and they say, I want to terminate this employee, and here's all the reasons. As long as the reason is not related to some sort of human rights protected ground, like you wouldn't want to terminate an employee because they're pregnant, for example, then you can terminate your best employee for no reason at all, as long as you're providing reasonable notice. Okay, so that can, you know, that surprises a lot of people, and it does offer you a way to exit people without too much fuss, although it will cost you some money because of the notice element. So the Employment Standards Act, or whatever minimum legislation applies in your jurisdiction, sets out the minimum amount of notice that employees are entitled to in without cause termination scenarios. So there's always going to be a minimum. If you have a valid contract, then that contract might set out that the employee is only entitled to the minimum. Most employers aren't going to have those valid contracts at this point, and the employee is going to be entitled to notice under what we call the common law. We'll talk more about that in a minute. For cause is the real, like, you're fired, get out type of thing. And it is pretty rare because it can usually be a bit of a pain, and the bar is just very high, right? So the employee needs to really have done something that makes any continuation of the employment relationship really untenable. And so if there's an opportunity for them to be coached and to show improvement, for example, we're usually not going to be at that for cause level. If you've followed a plan of progressive discipline, warned the employee, maybe warn the employee and they consistently don't improve, sometimes that can raise to the level of cause under the law, but it is pretty rare, other than situations like, if your employee is stealing money, or if your employee has threatened violence to another employee, like it's got to be really, really quite bad. So there are two types of cause, and one type is cause under the ESA, which requires that the employee's actions be willful, right? So the employee will be entitled to absolutely no notice of termination if they have done something willful. So willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. That's the language that will entitle the employee to absolutely nothing other than pay up to the last day. If their actions are maybe less willful, they might be entitled still to those ESA minimum entitlements, but nothing further under the common law. And the risk of terminating for cause, if you got it wrong, like if you accused an employee of stealing and it wasn't them, that could attract additional damages for an employer. And the employee who's terminated for cause and gets nothing is going to have a pretty big incentive to try to sue the employer for reasonable notice, just because they might be looking at, if they're a long-term employee, they might be entitled to months and months of notice. And they've obviously got that incentive, and these cases can usually be taken by lawyers on contingency fees, so that it won't cost the employee anything up front. Just looking, we've got a couple of questions here. So our website is a great place to check out, sort of for information regarding employment law. Employment Law 101. Yeah, go ahead, Danielle, sorry.
We have a blog. So we have a weekly blog that you can, look at, and we write about a lot of different employment law topics.
Yeah. Okay, Danielle, over to you for terminations.
Okay, so there are situations where you should avoid terminating. One of them is if the employee is on a protected leave under the Employment Standards Act. So that employee does have a right to be reinstated after being on the leave. So whether it be maternity leave or caregiver leave type thing. So you should avoid terminating when an employee is on a leave. And then, what we talked about earlier, the human rights considerations, such as a disability, you would want to avoid terminating until you can accommodate them to undue hardship.
Yeah, and so those are situations where, you could attract additional damages and liability if you're terminating is contrary to the law in the case of a human rights or a employment standards protected leave. And this is your slide here too, I think, Danielle.
Elements of termination packages. So if you are going to terminate and you've made that decision, most of the time you would offer a termination package. This is if you're terminating without cause. So, you'll look at, does the employee have an employment contract, a written employment contract? And you'll want to take a look at what are the termination provisions in that contract. Oftentimes, that's when people seek legal advice, because you'll want to know, is this contract enforceable or not? And courts are very frequently invalidating these termination provisions. So there's every year, there's different reasons why these termination provisions are found to be unenforceable. And if your termination provision limits the employee's entitlements to the Employment Standards Act, and it's found to, or you talk to a lawyer, the lawyer tells you that it is enforceable, then that will really limit what you're going to, or what you can offer your employee in the termination package. ESA entitlements are about a week per year of service, up to 8 weeks. If the employee does not have an employment contract, or if the contract is unenforceable, and let's say you include ESA notice only, that employee might go and consult with a lawyer on their end, and the lawyer is going to tell them, well, you're entitled to more. You're entitled to what? To notice under the common law, which Hilary mentioned, which can be substantially more money than the strict ESA requirements. So either way, you're going to want to set out in the termination package what you're offering them upon termination. And the ESA requirements do include notice, so a certain amount of notice or pay in lieu of notice, severance, if applicable, so certain companies will be severance payers, and vacation, or vacation pay, as well as benefits continuation during the notice period. Oftentimes, employers will offer a gratuitous payment in exchange for a release. So you would, require them to sign this release, which would mean that the employee will not start any action against you in the future, any action whatsoever, for any reason. And then in exchange for signing that, they would get an additional amount, a gratuitous payment, or an extra amount of money upon termination. And then finally, if the employee was receiving a bonus, or typically received a bonus, or was getting paid commissions or anything else, typically the employee would be entitled to that during the notice period, or possibly for longer.
Thanks, Danielle. And so if you are terminating for cause, which is again going to be fairly rare, in all termination situations, we would recommend that you get a lawyer. And I see someone's asked, what are the, what makes a contract enforceable? It's a lot of really technical legal reasons, and I really would recommend that you do have your contracts reviewed by a lawyer if you're thinking of terminating, or if you're thinking of rolling out new contracts, or if it's just been a while and likely they need a refresh. So in a for cause situation where you're thinking of that, it's typically even more important that you do get legal advice, just because those scenarios can be pretty tricky. When an employee is terminated for cause, if it's a true for cause situation, and that also meets that willful threshold under the Employment Standards Act, then the employee is going to be entitled to nothing other than their entitlements up to their last day of work. So they'd get their paycheck up to the last day. They'd get any accrued and unused vacation up to that last day. If there were commissions or anything like that that they earned up to that last day, they would still be entitled to that. And one thing that we often consider when we're doing a cause termination is we set it out in sort of a two-step package. So we still offer some sort of payment to the employee in exchange for that release, but we separate that offer from the letter where we talk about the cause and explain, this is why you were terminated for cause. I see someone's asked a question about
Oh,
can you
yeah, I hear you
terminate
now.
someone if they've been on disability for 2 years? So that might rise to the level of what we call frustration in the law. But that would only be the case if if you had medical verification from the employee that they were likely to never be able to return to their position. So if they're permanently disabled, for example, then that might be a scenario where you could effectively end the contract due to frustration. I would recommend you get advice on that. However, and moving along here, these 30 minutes always go by so quickly. We're going to talk
Okay.
about how to terminate an employee virtually.
So virtual terminations are, very common these days, especially with people working from home. Um, and so, when you're going to terminate virtually, you just want to, prepare ahead and think about how are you going to do this? Where's the employee going to be? Where are you going to be? And make a plan. If you're concerned about the employee taking information, taking client information or anything like that, any other company documents or information, you can set it up so that the IT cuts them off, shortly after termination. You want to set up, think about the equipment pickup and coordinate that, plan those details in advance so that it can just happen quickly. If there's a lack of trust there. And then just, setting the details of the meeting. Is it going to be by video or by phone? If there's a relationship there, often, giving them the courtesy of a video call, is sometimes better, and you can have more of a, face-to-face conversation rather than them just getting a phone call. But whatever makes the most sense for you is the way to go.
Yeah, we do recommend that you do it in person as opposed to like over chat or email. I guess like in the virtual environment. And there are those extra layers to think about, right? Like, are you going to send a courier to the employee's house? What do they have at their home? Um, have you kept a good record of that? So we've definitely seen a shift in what we need to consider when we're preparing termination letters. Okay, I was just going to answer a question here. There's a question about what about an employee who's terminated mid-year when the bonus is not yet paid, and would they be entitled to a prorated portion of that bonus? Often they would be, but it's going to depend on the terms of your bonus plan. So the bonus plan needs to be really clear about sort of when that bonus becomes payable, how it's earned. Is it earned over the year, or is it earned on the date it becomes payable? So those are things that you can carve out of a termination package, but often an employee is going to be entitled to the prorated portion of the year that they worked, the bonus for that year, and often also prorated bonus for bonus during the notice period. There's another good question here about probationary period. Is it true we can terminate someone within the 90-day probationary period without payment or notice? So that would be true if you had a valid contract entitling that employee to notice in accordance with the Employment Standards Act only, right? If you don't have a valid contract, no matter how long they've been your employee, they're going to be entitled to notice in accordance with the common law, and that's typically never going to be nothing. So that's a situation where the contract is really important. Okay, so virtual terminations, what to say and what not to say. So this really goes for any sort of termination, not necessarily a virtual termination, but you typically don't want to say a heck of a lot in your termination meeting. You don't want that to be the place where the employee brings up, oh, I've been struggling because I have depression or something, right? Ideally, you've looked into that ahead of time. But you don't want the termination meeting to be a place where the employee is going to argue with you or try to make you change your mind or raise reasons why you shouldn't be terminating them. So typically we want to say something about why the employee is being terminated, but usually that it's for business reasons, right? So maybe there's a change in the budget or something like that. If there is a very clear business reason, like we're phasing out your department, feel free to say a short explanation regarding that. In those situations, the employees often already kind of know. And then you're just going to want to basically tell them that they are being provided with a package and kind of explain the termination letter. So you can use the termination letter as sort of a template of what you want to say during your meeting. So it's going to set out the employee's entitlements. So usually their minimum entitlements, as well as maybe a gratuitous package, which would be like the common law type portion of the package in exchange for a release, and then details about return of their equipment or anything like that. If they have a non-solicit or a non-compete that would apply to their post-termination period, you might want to mention that, and that would all be in the letter. And again, you don't want to say, we're firing you because you were always late and we just don't like you. It's just not the time to say that, right? So the employer does have a duty of good faith in law in terms of the manner of dismissal. So you want to just be professional, be kind, no accusations. We see situations like accusing an employee of cause at the termination when that wasn't really true. Those types of things could attract additional damages for an employer, or if they were, unnecessarily mean or humiliating in the way that they terminated the employee. Those are things that could attract additional liabilities for an employer.
Okay, and then next thing would be, once you've had the termination meeting, then you would send the termination letter, often by email. And then usually the termination letter has a deadline for them to respond, especially if there's, an enhanced package with a release there. You want to give them, a relatively short timeline or deadline or turnaround time. And that kind of, will put a bit of pressure for them to accept it. Typically, or a lot of the time, employees will go and consult a lawyer and see, get that termination package reviewed, see if they're entitled to more, and then, within that timeline, they'll decide whether they are going to accept it, or if they are going to send a demand letter or ask for more, ask for a larger termination package. And then, other considerations are getting the equipment back. Are you going to send a courier? Are they going to drop it off at the office? And then, you just want to make sure you get that signed release, and then you're good to go. You don't have to worry anymore.
Yeah. So yeah, I see we're just about at time. We have lots of good questions, and I'm sorry we're not able to get to them all. We would be happy to answer your questions if you want to email them to us. And I see someone's asked, do we have a hotline or some service? Don't really have a hotline, but if you do become a client, I kind of think of myself as a bit of a hotline at times. I just answer these types of questions, from my clients all day long. So we'd be happy Happy to help you out. And a lot of these are, about disability and about reasons. So if you shouldn't be terminating an employee because of a disability, right? That would be in almost all cases discriminatory, and you would have a duty to accommodate that disability up to the point of undue hardship. We have other webinars on our YouTube channel about accommodation and about that type of thing, as well as more resources on our website on the blog about that type of thing. And in terms, I see there are a lot of questions about kind of reasons. You typically just don't want to get into the reasons, even if the reason is just like, this isn't a good fit. What does that mean? It could be potentially discriminatory, right? So if it's a good business reason, like you had to sell this much stuff and you just didn't sell that much stuff, fine. Something like that, that's kind of uncontroversial. I don't think you need to say absolutely nothing, but think about, is this a business reason? And what's the value of saying it going to be? Is the employee going to fight with me, right? If that's the case, maybe you don't need to go into too much detail. So usually less is more. Okay, and we're gonna sign off.
So that concludes today's webinar. Our next webinar will be on Wednesday, March 23rd at 10:30 a.m. Eastern Time, and it will be on budget-friendly legal services, practical tips to reduce your legal spend. So visit our website to register today, and please feel free to follow up with any questions that you may have. Those who had questions that we didn't get to answer, feel free to reach out to us. And for more information, you can visit our website at springlaw.ca. Follow us on social media. We're on Facebook, Twitter, LinkedIn, Instagram, or our YouTube channel where you can see other webinars. And sign up for our monthly newsletter to stay up to date. Thank you everyone for joining us today.
Yeah, thanks for joining. Bye everybody.
Bye.